Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. Continuing on with the quick-hitting communication basics. So we're back to basics at the beginning of the year, talking about communication, focusing on communication with the other agent right now. And this one's going to come from the buyer's side. So here's your situation. Earnest money is due. The deadline comes and goes. You're 2 days past the deadline, still have not received earnest money. You've been trying. You alerted your buyer, hey, you need to get this in. They just haven't, whatever. They're traveling. They're just lazy. I don't know. But they're not getting it in. Now, what is your obligation, restriction as a buyer's agent? Well, let's look at what's happened. Your buyer's missed a deadline in the transaction, in the contract, right? So they've really breached a portion of the contract. It's a promise that's gone unfulfilled. I will deliver earnest money by this deadline. It's coming on. What does that kick in? Well, the Code of Ethics, Article 2, says you got to disclose pertinent information about the property or transaction. Well, here you have a breach of the contract, which I would think is at the level where a seller could cancel the contract based on it, and you have you're not disclosing that information. I would argue that I believe Utah law would require you to disclose that, at least in the licensing sense, and the Code of Ethics would require that. And I believe I've had discussions with the division, with some folks at the division who've said, yeah, we think that is something that would be required to be disclosed. So in this case, it's, even though a buyer may not want you to disclose that information, I believe you're required by the Code of Ethics, and I could argue you're required by licensing law to disclose that. So I think there's a duty to disclose that there's been a breach, a material breach of the contract, which I would, in my opinion, say earnest money not getting in on time is a material breach. Now, the time to have that discussion with your buyer is not at 4:30 on the deadline day, right? It's when you write the contract, when you explain if this gets accepted, you have till this time and day to get that earnest money in. And if you don't, I'm required to disclose that to the other side. Now, could the other side give you an extension? Yes, but let's not rely on it, because potentially you could get kicked out of the contract by not having that in. So good communication with the buyer up front, but then you're going to have to disclose that when it happens. So be careful. Remember, this is not legal advice. This is legal information only. If you need specific legal advice, please contact your attorney. Thanks for tuning in.